Yes, good morning, Mr. Officer. I'm sorry we've kept you waiting for a few minutes.
Good morning, Lord Chepson. So I said in opening that I would divide my submissions into 4 parts. We've covered the first 2, so that leaves parts 3 and 4. Part 3 is looking at the tribunal judgment and just picking out some points that I want to make on the tribunal judgment. And then part 4 is responding to the grounds now advanced by my learned friend, which is now grouped into 4 groups of grounds. And then there will be a short postscript dealing with remedies and one other point. In terms of timing, I'm aiming to be finished before 12:30, which is when I'm timetabled with my learned friend to finish that. We'll give him at least half an hour for a reply before we are due to end at 1 o'clock today.
Excellent.
So, the Tribunal's decision, it's obviously in core bundle at tab 7. If I invite you to turn it up, what I'm going to do is just go through it, read out every paragraph, but I'm just going to pick out the points that I wish to make specifically on it, other than those that I'll come to when I deal with the part 4, the individual grounds. The reason why I want to look at the judgment as a whole, as it were, is that my learned friend's approach here and below is to be fixate on the decision of the 22nd of March 2024, the Part A, Part B, public meeting, private meeting of the authority. And by the way, while I mentioned the meeting of the authority, just a point on terminology, the tribunal referred to it as a meeting of the GMCA committee. And that's
it is the GMCA.
It's the authority, yes. It was a point we picked up on below in front of the tribunal, but I'm afraid when we got the draft judgment, we didn't correct it. Nothing turns on it, it's shorthand, but it just means the authority.
I don't think we need to get into the particular constitutional arrangements for local government in Manchester, but it's apparent that this consists of the mayor and representatives of other constituent councils, and that makes a combined authority which takes decisions of the state.
That's right, 10 constituent councils. Yes. Starting on page 71, we see the introduction, and then turning the page, 72, the procedural history. The first point to pick up on.
Are we concerned with, I mean, there's quite a lot of procedural history. Are we concerned with any of that?
I just want to respond to some points that had been made against me, which I pick up as I go through it. But no, we're not. We're not. Nothing's going to turn, I think, on the procedural history, other than this point. This is just to reiterate the point that I made yesterday afternoon. Paragraph 16, the absence of expert evidence.
Yes.
And the tribunal had more than adequate expertise. 2 members of the panel with extensive banking and lending experience, able to understand the process and form a clear assessment as to the terms of the 2024 loans.
Do we have anywhere in the papers a statement of the terms of? We don't have the facility agreements, the mortgages, and so on.
No, they were in evidence below.
But there's a sufficient statement, is there, somewhere, of the terms, or?
Yes, it's specific. The relevant aspects are described in the tribunal's judgment.
Yes, that's what I thought.
Yes.
We don't need any more than that.
No. So you are spared, for example, the facilities agreement, which runs to several hundred pages.
Some of us enjoy reading long documents.
The tribunal wanted a potted guide to it, which we gave them. There's the then starting at paragraph 17. There's the overview of the fund, and just to pick out the point of paragraph 18, the fund closed for new investment in March 2025. It's now in run-off and can't award new loans.
Does the run-off mean that all the existing loans will be repaid by 2028?
Yes.
What are the terms of these loans? They were actually drawn down in November. Are they 3-year loans?
I can only speak to these loans.
Yes.
Obviously, there are a number of other loans.
Yes.
For these loans, they're still being drawn down. roughly 2/3 of the loans have been drawn down. Essentially, drawdown proceeds in stages as construction takes place.
And how near the completion are the buildings? I mean, is this still a hole in the ground, or is it?
No.
This is
the concrete frames are there and being the apartments are being built. So they're going up on the Manchester skyline.
Is there a target completion date? Do we know?
It is March 2027. March 2027.
Thank you.
And there is a description of the primary objective of the fund, paragraph 19. So this is got other objectives, that's paragraph 20. And then over the page on page 26, paragraph 21. The fund's been revenue generative for both the authority and central government, and that's set out there. Paragraph 22, the fund has not lost any money. This is just simply to make the point that forensically, it's in the authority's interests for funding to be on proper commercial terms to generate revenue, which it has to pass over to central government up to a certain level, as determined by the state aid rules, and then above that, interest fund that's generated goes to the authority, which it then applies for its other public interest objectives, construction not only of housing but of other facilities.
But presumably it also has an interest in the centre of Manchester being regenerated, in new building in any event.
Yes, absolutely. It's
so this is not just a financial transaction; it fulfils public policy objectives.
Yes, absolutely. So, I mean, for one of the one of the benefits of regenerating Manchester city centre has been to encourage, because of its residential development, encouraging people to move back into the city centre, to have become hollowed out. People now moving back into the city centre. One of the projects that has been supported through planning, not specifically as it's Section 106, which is the planning authority, that's not this authority, has been the construction of a new primary school with funds generated from Renaker. The primary school is called Crown Street. It opened in September 2024. It's the first new primary school in approximately 20 years in the Manchester city centre. So that's that sort of urban regeneration.
But that sort of benefit presumably is irrelevant from the CMO principle perspective.
It may be politically relevant.
Yes, but that's not what the CMO test is about.
It's not what this case is about.
No, it's not what the CMO principle is about, is it?
Oh no, sorry, I thought you said CMA. No, CMO. No, that's not what the CMO principle is about. CMO principle is about acting as a commercial funder. And then we get that at the next section on page 76, process of awarding fund loans. The process has several stages, and that's what is then described. It includes the delegation of authority to public GMCA meeting. This stage does not confer on the borrower a legal right to receive the loan. This only comes on completion of the loans, which occurs once GMCA solicitors have received the authority from GMCA to go ahead and complete on the basis of sealed and signed loan documentation, as is the case for a private sector loan. Paragraph 24.
Just pausing there, I mean, we can see from the terms of the resolution passed in March that there's a delegation of finalisation of the legal terms and so on. But who gives authority to go ahead and complete? It doesn't seem to come back to the GMCA itself.
It's the treasurer. It's the GMCA treasurer.
Right. Yeah. Thank you.
And as we see in paragraph 24, this process, and I want to emphasise, it's a decision-making process. You don't just consider the public meeting on the 22nd of March in isolation. This process was developed by GMCA in consultation with external banking and consulting expertise and was intended to allow the GMCA to perform a similar level of due diligence to a private sector lender. The process is reflected in the fund's revised investment strategy dated 25th of October 2019. And so it's revised because the original fund was set up in 2015. The original fund was with Manchester City Council. It was novated to the authority in 2019. The tribunal then set out the governance arrangements. The core investment, in paragraph 5.1, the core investment team is responsible for managing the fund. Both the Gateway Panel and Credit Committee have been set up and been operating over the 4 years of fund operation to review proposals and provide the necessary approvals before recommending the projects for approval by the GMCA. As part of good governance, the Gateway Panel membership was rotated and 2 new members were appointed. 5.2. The role of the independent Gateway Panel is critical to ensuring external scrutiny of projects being approved. The panel is considered to include all the necessary expertise to provide the appropriate level of scrutiny to projects. 5.3. Projects are fully developed before being presented to the Gateway Panel, such that they review all the detailed information prior to approving projects. This results in 2 separate committees reviewing detailed proposals for investments of more than £2 million before approval is recommended to the GMCA. And then 5.5, the existing governance arrangements for the fund include regular sharing of management information with government departments to allow for national monitoring of counterparty exposure. And that also, of course, allows central government to check that it's getting its due share under the facility agreement. Fund risk management is set out in paragraph 6, and it identifies the aspects that it will be taken into account. And the last of those bullet points, loans will be priced to reflect the risk of each project. And then you see at paragraph 6.3, perhaps just to pick up on the point that my lord was raising, there had been a review in 2019 into further city centre investment. That review concluded that demand continues to outstrip supply and supports the city centre investment decisions taken to date and to be made in the short term. City centre schemes are being considered in the future, and non-city centre schemes continue to be subject to location-specific rental valuations to confirm demand for specific projects prior to investment decisions being made. There's provision for an annual review by the Manchester City Council Internal Audit Team, paragraph 6.4, and 6.5, critical success of the fund is the ongoing monitoring of projects and ensuring timely repayment of funds. And then paragraph 6.6, a separate monitoring team with appropriate skills and experience has been created within the core investment team to provide focused technical oversight of all loans being provided. So it's managed appropriately by the authority in accordance with this revised investment strategy. This isn't, there's nothing obviously in the Subsidy Control Act or in other legislation that says these are the steps that have to put in place. This is the authority determining how this fund should be managed to achieve its objectives. And then paragraph 7, legal considerations. 7.2, the pricing of all types of loans will be risk-based following an assessment of the borrower's financial covenant together with the strength of collateral available for the loan. In order to ensure that lending complies with EU state aid regulations, of course at this time the EU state aid rules applied, they didn't come to an end until the end of 2020. Minimum interest rate margin will be determined using the state aid table published under the communication from the Commission on the revision of the method for setting the reference and discount rates. So that's the reference rate communication as we've been referring to it. And that's how that comes into play under the investment strategy.
But it also, we were told, comes in 7.1 refers to a legal agreement. MHCLG, I assume, is the Ministry of Housing, Communities and Local Government.
Yeah.
We were told that there was a requirement in there to comply with.
Yes, and that's the revenue split, or the...
well, no, but there was a requirement in that legal agreement to have regard to the EU reference rate?
Yes.
Yes.
Yeah, because they had to have regard to it because that is that then imposes the obligation on the authority, now party to the agreement of innovation, to pay up to that amount to central government.
We haven't got that legal agreement, but there's no dispute.
There's no dispute. It was before the tribunal.
Yeah.
And then what the tribunal do is set out the stages of the loan decision-making process at paragraphs 25 through to 73. So it goes through the various stages that the authority goes through in deciding whether to proceed, or giving the loan proposal and then deciding whether to proceed with it. So the initial consideration of the loan is set out at paragraph 25. There's no formal application form. It's not a box-ticking exercise. Inquiries are made to the authority. It's obviously publicised, the existence of it, but that's contact is made with the authority. Paragraph 27 refers to the transaction manager. So an employee, such as Mr. Walmsley, will have responsibility for the transaction and to seeing it through. So the initial stage, is this a viable proposition? Paragraph 29. If it is, then the transaction manager will write a gateway paper. And that's on a pro forma basis. So that's the document you have seen. You've seen it for this transaction. It goes for all funding under this fund. There's nothing specific to Renaker. It's the process under this fund.
Where is the gateway paper?
That was the one that my learned friend took you to in the... Oh, sorry. I had in my mind the IRSRP, the interest rates.
I thought the IRSP is post facto.
It is, yes.
We haven't got the gateway paper.
No, you haven't got that gateway paper. It was before the tribunal in evidence. That's why I've got a copy of it, but it's not in the bundles before this court. So it's described.
Does it include the proposed interest rates?
It does. So that's part of the initial information gathering. So that's what Mr. Renaker was doing when discussing with Mr. Whittaker, Mr. Whittaker's propositions for 2 more loans to cover treaty and we call it contour. You see the gateway panel described from paragraph 30 onwards, and in particular paragraph 31. The gateway panel consists of 3 independent external advisors who all have significant experience in the private house building sector. The gateway panel is there to assess the robustness of the investment case. The gateway panel considers all the salient points from the gateway paper that's presented to them. So they're looking at, amongst other things, the rate proposed for the loan. That process in front of the panel continues up to paragraph 33. Then the next stage is if the gateway panel agree for it to proceed, it goes to the credit committee. We get the same gateway paper and then get an individual, a further one-page document provided by the credit manager, who's independent of the gateway panel, focusing on financials, security offer, cost overrun, guarantee, etc. And then the composition of the credit committee, paragraph 36, consists of a mixture of senior GMCA staff members and external advisors. And it's focused on how robust the proposal is in the terms of the likelihood of repayment of the loan, as the name of the credit committee would suggest. So once it's been considered, the next stage as it goes to, if it's going to proceed, is to go to the GMCA chief executive and the treasurer. That's technically part of the credit committee stage, according to paragraph 38. If the chief executive decides that it should proceed, paragraph 39, the application goes to the authority portfolio leader. Essentially, authority members have different policy portfolios, they're effectively cabinet members. It will go to the portfolio leader with responsibility for the housing portfolio. And then the summary papers provided to the portfolio leader, similar to the Part B report, which will be provided to the combined authority. The process for portfolio leader considering it, a monthly meeting, is described in paragraph 40. The next stage is preparation of the Part A and Part B reports to go to the authority. That's paragraph 41. Part A is a high-level overview. Part B is more detailed, the commercial terms, including the interest rate. So that's paragraphs 41 to 43. We then come to the GMCA public meeting, and that's described at paragraph 44. And if approved, the GMCA will delegate authority to the treasurer, acting in conjunction with the monitoring officer, to review the due diligence and sign off on the commercial terms and legal documentation in relation to the loan application. Then paragraph 45, heads of terms can be issued to the borrower before or shortly after this stage. In this case, they're issued about a month after the authority meeting. Obviously, being heads of terms, they're not legally binding, and they consider elements such as the loan amount, security of the term, diligence requirements, and they form the basis of discussion with the borrower on the terms and ultimately the legal documentation for the loan which is to be drawn up. And the tribunal makes the point that in this process, which it's describing in this is how the process normally works, after the public meeting, that stage is at the end of paragraph 47. This stage is followed by a due diligence process, which may alter the terms of the proposed loan. And as we'll see when we get to these particular loans, that actually did happen. Loans may fail to proceed after the public meeting. There was evidence before the tribunal that a certain proportion didn't proceed. Look, they may fall away for whatever reason, but maybe it was the applicant decided to get better terms from elsewhere. Right? They've got a private sector lender who's willing to provide better terms. From paragraph 49 onwards, the further due diligence is described. So there is, looking at the value of the property, that's been done on a desktop basis. But a detailed valuation is required, but that only takes place, usually only takes place after the public meeting. And it's valued by an RICS surveyor in accordance with their principles. In addition to that, there's a report by an external monitoring surveyor who reviews and opines on the construction costs and other construction matters, and that will recommend what collateral warranties the authority may wish to take, which is a way to tie the contractor and subcontractor into the agreement with the borrowers. On to page 83, other stages, letters of reliance may be recommended, legal advisors instructed to carry out legal due diligence, and all of these to be reviewed, all of these due diligence review reports to be reviewed by the credit manager. That's subject to the supervision of the Director of Strategic Finance and Investment, who is, for these loans, Laura Blakey, who's in court today. You then get sign-off by the Treasurer, paragraph 56, and then following sign-off from the Treasurer, after consideration of due diligence outcomes, then you get into the legal advisors drawing up the documentation. Paragraph 58, loan documentation drawn up, signed, sealed, formal completion, and it's at that point, paragraph 59, that you have the legal right to the funds. Then there's drawdown, and how that is monitored by the monitoring surveyor and supervised. That's paragraphs 63 to 62. Then how the loans are priced, specifically addressed here by the tribunal as the normal approach, and that's set out there. Risk margin applied on the top of the state aid rate, reflecting the risk associated with the individual loan being considered. Paragraph 66, and this is a point my learned friend criticises the authority for, GMCA does not tend to look formally at other loans available on the market. So it doesn't do a consideration of what other funders might be funding at. But it does have market intelligence on what other lenders are charging from various sources, not least potential borrowers coming to the authority with an indication of what they might be charged elsewhere. Paragraph 67, it also has intelligence from loans, club loans, where it's lent on a pari passu basis with other commercial lenders. And the examples that arose in these particular transactions, reference being made to when the College Yard and Lane developments, in which the authority lent pari passu with the Greater Manchester Pension Fund, which is a very significant commercial lender on a commercial basis. So it then goes on to look at other factors taken into account. Subsidy control safeguarding, that's dealt with paragraphs 70 to 71. It's essentially, there's two elements to it. It's the state aid reference, communication, and then the 2022 regulations. And those just check that they are charging at least the rates that would be indicated by that communication, those regulations. But 72, given that a risk premium is being added to the interest rate, those checks tend to show that the higher interest rates charged by loans given under the fund are well in excess of state aid and subsidy control levels. The risk premium is intended to reflect GMCA's view on construction risk, market risk, developer risk, strength and security.
Can I be sure what the reference to the state aid reference rate in paragraph 70 is?
It's the table of rates attached to the reference rate communication. So the Commission notice concludes with a schedule of base rates, member state by member state.
Yes, and for the UK, in March 2024, it was 5.35%.
Yeah.
Is that what the state aid reference rate is, or is it? When you look at the communication, it then has, in addition to that, depending on the strength of the covenant and the collateralisation, a matrix, as it was described, a table setting out the number of basis points that you should add on top.
Yeah. It's the exercise under the communication. So it starts with the base rate, and then you add additional amounts. And Malone and Friend says what they didn't do was add 4% because it's an SPV, and we said, well, that was an entirely rational thing to do.
Yes, but when it says the facility agreement requires that at least the state aid reference rate is charged, does that mean 5.35%? Or, if Mr. Barrett's right, 9.35%?
It is the amount that would be applied under the reference rate communication, so not just the base rate.
It includes the necessary margin. But if he's right on the construction of the reference rate communication, then the minimum charge should have been 9.35%. That's what he told us.
Yes. Yeah. And we'll come to what the tribunal make of that submission.
Right.
Because the next section we've just got to is the 2024 Renaker loans, starting at paragraph 74. And this runs through to 99. And again, I'll just go through this section by section.
Yep.
And I'll come to the point. So, having set out the authority structure, then looks at what was done in this case. And that's set out the initial meeting to get an indicative interest rate, 74 and 75. 76, the Gateway Panel meeting on the 22nd of February, tended by Mr. Fitzsimmons, who was the chair of the committee, former chief executive of Redrow Homes and Appellant Homes, Ms. Hurst, managing director of Maple Grove Development Division of Drake White, and Mr. Chilton, managing director of Rowlandson, experienced contractor and developer. So, heavyweight, private sector expertise in the GMCA committee. So if they looked at the interest rates that were being proposed and said this is far too cheap, they would have advised the authority, you're underselling, you're not getting sufficient return for your investment. Why would the authority want to do that? So that's the independent scrutiny that takes place.
Sorry, can I just go back?
Yes.
Sorry, I'm a bit slow. Under the facility agreement, the GMCA has to account to central government for interest up to the state aid reference rate.
Yes.
So if Mr. Barrett is right to say that the state aid interest rate, reference rate, is the 9%, we'll just call it for present purposes, as a matter of true construction, this could be a pretty poor loan for the GMCA to have made. because it's got to, the GMCA is going to have to account for more interest to central government than it's charged.
If they banged on the extra 4%,
Yeah.
Mr. Brown, I think Mr. Whitaker would have run for the hill. Well, he would have run off to an alternative source of funding because it would have made it completely uneconomic. We'll see. We'll get to that point where we examine how the interest rate is comprised. We'll get to the actual documents in here.
But on the assumption that they're right about that the appellant is right about that, then this is a loss-making arrangement, isn't it?
No, it would just be totally unviable.
Well, no, it's happened.
No, I may be able to help. I don't know if it's assistance. I think the point the Lord's putting is that there's a process whereby central government would, as it were, do their own sum and say, terribly sorry, GMCA.
Yeah.
So as far as
it's a contractual obligation.
Indeed, but as far as the evidence we've got indicates, there's no such process in the evidence, certainly below, of central government doing that sort of individual transaction analysis and reconciliation. I think my respectful submission as a matter of the construction of the contract, what my Lord is saying is absolutely right. But as I understand the factual position on the evidence, there is no such process or exercise conducted.
Right, so if I think on this particular point, I would have to address it in writing. I don't have the document.
All right, but it may not matter, just...
In my submission it doesn't, because when you come to see how they calculate the interest rate and why they don't use 4%, then you'll see how they've arrived at a commercial rate.
That's a different question, though.
Yes.
I mean, the question whether it's a commercial rate is a separate question from whether the central government has a contractual right, which is what we're told in the decision of the CAT, whether central government has a contractual right to receive interest up to the level of the state aid reference rate, which must be a separate question, but there it is. It may not matter.
It's not been raised in those terms. It wasn't raised in those terms below, and if it had been, we'd have addressed it. So I'm back at paragraph. I am back at page 87, paragraph 76 of the Gateway Panel, paragraph 78, the Credit Committee, and that's attended by a further external scrutineer, Mr. Tony Goldrick, from formerly of the World Bank of Scotland, specialising in real estate, head of the corporate real estate team covering the north of England. So again, there's that independent check on the terms of the proposed loans to ensure that the authority is getting a proper return on its investment. That then turns over the page to 88, to paragraph 81, the public meeting, the Part A report, which is set out in paragraph 82, the Part B report, not public, going to the authority, is set out at paragraph 83, setting out the funding proposals, lending to Renaker, halfway down the page, second paragraph, GMCA has to date provided loans for 8 Renaker developments, 2 of which are currently live. So this is part of the authority has considerable experience of funding this type of residential development with this funding. On page 90, we have the programme and exit strategy, noting that construction has commenced for both schemes. Financial information is set out 2/3 of the way down page 90, including not only the loan, but the arrangement fee. And then on page 91, the minimum lending of £120 million, adopting the higher margin for the interest on the Trinity loan. Proposals forecast to generate the levels of revenue set out there. And it's also, of course, there's the loan management fee referred to at the top of page 91, which was mentioned yesterday. Then there's arrangements for security, conclusions and recommendation, and recommendation to authority to approve the lending. Then the investment proposal table contained in the gateway paper. So we don't have the gateway paper itself, but we do have this account of it, and set out in detail on pages 91, 92, 93. And then pricing starts at the bottom of 93.
Was the gateway paper before the GMCA?
It was no, it doesn't. No, this doesn't go to the as part of the Part B report. So the Part B report contains information taken from the process, but the gateway paper itself, which is what this is, that doesn't go to the authority. And there you'll see the way in which the various elements of the proposal, which were approved by the Gateway Committee and the Credit Committee, are set out. And pricing, as I said, is page 93. So you'll see that it's the EU reference rate, that's the base rate, plus the state aid additional 1%. And then on top of that, fund risk premium, different levels for Trinity and contour, and the note there that the Trinity interest rate would reduce if the scheme is forward sold, which in fact it was. And note there that for each facility, a certain amount of the fund risk premium is to be charged as a loan monitoring fee, and that leads to the total rate proposed set out there for each of the loans.
So the fund risk premium is on top of the reference rate,
Yes.
and the state aid rate,
Yes.
at the figures shown at the bottom 93. you add that, and that produces the total rate proposed. Yes, I see. Thank you.
What's published is set out in paragraph 85. We then get to the interest rate setting paper, paragraph 86. This is a paper that is first put together. So it's on a, say it's something which is done for every loan that's approved by a public committee. It's then part of the authorities, the investment teams monitoring of the interest rate that's being used for the loan. So it's a paper that there's Malone friend suggested below, and I think may have hinted at this, that this was somehow generated in response to the inquiries from his client about these loans. It wasn't. This is just a standard process that is done for every loan under the fund. And it provides
The footnote on page 95 says there were 10 drafts.
Yes.
Do we know when the first draft was?
Yes. The data's given in the decision. The first draft is in April.
You can see it if the actual document is in the unagreed bundle. It's tab 26, page 306.
Yeah, so we did go into this with the below, and the earliest version that we've got is dated April.
April 2024.
Yeah.
Yes, for your note, my lords, it's unagreed bundle, first unagreed bundle, tab 26, page 306, and you'll see the timestamp. It's on the 19th of April, so that's 3 days after the pre-action letter.
So that's tab 26. Tab 27 is the final version, isn't it?
Yes.
And you see it's constantly updated as more information comes in. And it gives a contemporaneous account of the interest rate and the rate being used. And that's obviously important if there's going to be an audit by central government as to what rates are being charged. So it's a contemporaneous account. It's not ex post facto reasons, as one of the friends argue. It's part of the process leading up to the final granting of the loans on the 22nd of November.
But can you, for my benefit, explain how it fits into the decision-making process then? Because the decision to grant the loans is made in March. There's delegated authority to the Treasurer to sign off on them, and he's the one that will receive the due diligence. What about this process? Mr. Walmsley drafts this paper. How and if at all, is it factored into any decision-making process?
It is an account of the decision-making process, so it doesn't, as it were, it doesn't go to decision makers. You'll see the tribunal state that. It's an account of why the interest rate was set at this level in the decision-making process. So it will change if there's been a change to the loan arrangements prior to final entry into force of the loan. For example, there were some minor changes made, which have reflected in the last iteration of the paper. One of the other changes was the liquidation of XQ Developments Limited.
So for example, it arrives at the 3.65% margin for the Trinity loan. It does that by adding 10 basis points for this element of risk, 10 basis points for that element of risk, and you get to the total. If that's identifying or recording what has happened, then where is Mr. Walmsley getting that information from? If he's recording a decision-making process that's taken place earlier, how is it getting into his report?
That's the proposed. The way in which the loan is made up is the proposal that goes to the authority in the public meeting.
Well, that would mean that the detail that we see in the IRSP was before the meeting on the 22nd of March, but we don't see that in any document, do we?
It was. It's put together by the transaction manager.
Who is Mr. Walmsley, yeah.
So he's been involved in this from the original proposal. So he's been involved in putting the paper to the Gateway panel and to the credit committee.
Yeah.
The paper goes the same way, but goes to both. So it's within his knowledge that this is how the interest rates have been arrived at.
Is there any finding about any of this, or was there any evidence about it?
I think I do need to rise in relation to this, my lords. Another friend is now giving evidence on his feet. You've got the only witness statement that's been given in the proceedings by Mr. Walmsley. It's in the unagreed bundle. It's a witness statement that was submitted after the hearing had concluded, and after he heard and watched the hearing with all of my detailed criticisms of the process. Even that witness statement after the hearing does not explain any of these matters. And the suggestion that's being put to you now as evidence that Mr. Walmsley and the contents of that paper somehow reflects whatever was in Mr. Enevoldson's head when he was negotiating with Mr. Whittaker, that's certainly not any evidence. It's not the subject of any finding. And I say that speaks for itself.
Well, paragraph 87 of the decision says, and it's not an easy sentence to understand, the IRSP therefore reflects the information that has gone through the rigorous approval process, namely the Gateway Panel, Credit Committee and public meeting. So there is a finding that somehow it reflects the information, but it's not clear to me whether that means, what that means as to what information the public meeting had.
Yes. So, my lord, I think I need to rise. I'm very concerned that you're not misled about this. It was common ground, absolute common ground before the tribunal, that the only material before the GMC committee was the party and the Part B report. If we need to get the whole transcript and take you through that, we can do that. It would be regrettable if that was necessary.
There's no dispute about that. We're perfectly clear the ISRP was not before the authority on the 22nd of March. It began life, as it does, after approval of the loans at the public meeting. That's when the ISRP, for any transaction, starts, and it is simply an account of how the interest rates have been calculated, so that you have a contemporaneous record of what the authority has been doing. And I was asked, where does the information in the IRSRP come from? Well, it's put together by Mr. Walmsley, and he's been involved as the transaction manager from the outset.
But that paragraph 87 looks to be just a almost verbatim quote from Mr. Walmsley's witness statement.
Yes.
But that there was no clarification then, because the statement came after the hearing as to what he meant by that.
No, we were asked. My learned friend got quite het up on me making points on instructions from those sitting behind me today, sitting behind me in the tribunal. And so we said, well, okay, we'll serve a witness statement, and the tribunal asked us to do that, just to confirm those details. That's what we've done, and that's where, as you pointed out, paragraph 87 comes from.
Just for completeness, there is a finding in 196 that the IRSP was not presented to the committee, as they call it. It's described as an internal and evolving analysis for internal purposes, as well as to provide the basis for compliance with the facility agreement.
Yes. So if the central government wants to come in and audit us, there's the material. And I was going to come on to those paragraphs in the judgment when I deal with the specific grounds raised by my learned friend. We're almost at an end of going through the tribunal's judgment, just for the interest rate setting process and for the general process. That is picked up where we've dealt with heads of terms on the 24th of April. That's on page 102, paragraph 89. There are then meeting of the Overview and Scrutiny Committee, 14th of August 2024, paragraph 93. Red Book valuations, paragraph 94. Neither of which changed the original view of the estimated value of the sites. The Credit Committee met on the 15th of October 2024, this is paragraph 95, approved of matters arising from the proposed forward sale of Trinity, so that leads to the reduction of the interest rate. And also amended arrangements around payment of arrangement and cancellation fees. So there were changes to the financial deal with the borrower that took place were approved in October 2024. I've already referred to the liquidation of XQDL, paragraph 96. Paragraph 97, project cost reviews obtained by external monitoring surveyors, dealing with matters about collateral warranties, station plan conditions, and other such matters. The Credit Committee was provided with a note, this is paragraph 98, on the detailed terms of the forward sale agreement for Trinity. And then final wrap-up report seeking Credit Committee approval, created on the 19th of November. Reports on title, 22nd of November, and then the loans are then executed.
Sorry, so I don't think I got an answer to the question I asked earlier. We got sidetracked. The IRSP talked about where it came from, but I asked where does it fit into the decision-making process thereafter. So it's never referred back to the GMCA. I don't think there's any finding as to what happens to it, other than it goes through iterations by Mr. Wormsley.
It's a contemporaneous account produced by the authority, and
but by Mr. Wormsley.
Yes.
And is there any evidence of anybody else ever seeing it?
It's not produced for submission to any authority or government department. If central government wishes to audit and asks for details of interest rates, that is a document that would then be provided for each of the loans.
It's not part of a decision-making process, it's a record
Yes.
of the factors which Mr.
Yes.
Wormsley said fed into the decision.
Yeah, it's a contemporaneous account.
Yes.
And it's no more than that. we were perfectly clear before the tribunal, this wasn't part of the decision-making process. It's an account of the decision-making process, and therefore of relevance. It's not something that, it's not ex post facto reasoning. And that's why we don't need to get into case authorities like Kenyon and the taxis, wheelchair taxis case. It's something that was happening alongside the due diligence process carried out by the transaction manager as an account of what was happening. Should there be questions raised, should there be an audit? So that's what I wanted to take the tribunal, sorry, I want to take the court through the decision-making process. So it's very much more extensive than just simply a one-off meeting in March. With that, and the remainder of the tribunal judgment is then dealing with the various grounds that my learned friend advanced below. But since he's shuffled his deck of cards on that and presented them in a different order, then it's better if I go through his grounds in the order that he presented them yesterday. And this is part 4 of my submissions. The first point, so dealing with my learned friend's first ground for you, which is his 4th ground from his grounds of appeal, and this is essentially the role of the statutory guidance. Our submission in relation to the statutory guidance, and we looked at the legislative basis for statutory guidance yesterday, is that the authority took a rational approach to the existence of statutory guidance and didn't involve any error of law. The tribunal's conclusions on the statutory guidance, and let's turn back to the tribunal judgment here, at page 147, starting at paragraph 202, and this was my learned friend's submission below, and the tribunal concluded the GMCA had a duty to have regard to the guidance and to apply it unless there was good reason to depart from it. The guidance sets out various ways in which a public authority may satisfy itself that any lending complies with the CMA principle. It suggests that this should be done by evidence-based assessments, such as using evidence that's specific to the financial assistance in question, obtaining the existence of assistance of experts, including independent experts, benchmarking and profitability analysis. So that's what the guidance says. Here, the GMCA did not conduct any profitability or benchmarking analysis, nor did it obtain a third-party report, and those are matters that my own friend criticises the authority. All these steps are envisaged as possible routes to a public authority to satisfying itself that any lending is compliant with the CMA principles. That said, it's evident that the GMCA did not have any doubt whether the lending infringed the CMA principles. That's referring to paragraph 15.7 of the statutory guidance. The GMCA could have chosen to commission a third-party expert or conduct benchmarking or profitability analysis, but even in the absence of these steps, the tribunal is satisfied that the GMCA could reasonably conclude that there was no subsidy. The GMCA itself had a great deal of experience in lending and understanding the lending market. Not only was there the investment team, but within the Gateway panel and credit committee, there were experts in the field of lending. As already noted, there was recent experience in lending on a club basis. That's the Greater Manchester Pension Fund examples, which I've just mentioned, where there was an independent expert report, that's from the commercial estate agents Avison and Young, that looked at the market. Taking into account the terms of the 2024 Renaker loans, the security conditions, those loans posed a low risk of loss, and it was highly probable that in the event of a default, the GMCA would have been able to recover the sums outstanding plus interest and costs. The actual margins applied above the base rate were not manifestly low or below the rates that can be expected to be available on the market. Paragraph 203, the Tribunal does not consider that in all circumstances the GMCA had failed to have regard to the guidance. They could have done more, but in not doing so, this did not constitute a breach of duty, as in not taking specific steps suggested in the guidance, as the approach taken was rational and the rates adopted were justified and by no means appear to be low and unduly favourable rates outside those that other commercial lenders would most probably be willing to lend at. Whilst the rates appear to be commercial rates that one would expect other funds on the market would be willing to offer the SPVs, the Tribunal does not consider that the other justifications for the 2024 Renaker loans and the papers before the GMCA, when it made its decision on 22nd of March 2024, in any way detracts from that, such as people sites and so on, those other matters. So, and the Tribunal's looked at the substance of the guidance and has concluded that the authority was looking at the substance of those issues and satisfying itself that there was no subsidy.
So, in the middle of paragraph 202, the Tribunal concludes, the Tribunal is satisfied that the GMCA could reasonably conclude that there was no subsidy. Where do you say, when and where did the GMCA reach that conclusion?
In the Gateway Panel and the Credit Committee.
Even though we've seen the minutes of the Gateway Panel and the Credit Committee, and they don't say in terms, we're satisfied there's no subsidy, or we're satisfied these are commercial rates, CMO rates. So how do we get to the conclusion that the Tribunal was right to say that the GMCA concluded there was no subsidy?
It's right, they're not minuted. You only normally minute action points, things that need acting upon. In our submission, if these had been below market rates, then the Gateway Panel would have said so. And the Credit Committee would have said so. The independent experts sitting on those committees, that's one of their functions, is to bring their private sector expertise to bear and advise the authority if it's not, essentially not getting a good deal for its investment. So it is that the process would have called out unreasonably or uncommercially low rates and didn't. That's what we rely upon. That's what the process was there for, as you've seen from the governance provisions that we've already covered.
Is the Tribunal to be read as saying that the GMCA did reasonably conclude that there was no subsidy, or that it could have, in the sense that it's something, a view that it could have reached? Because it didn't actually, the GMCA didn't actually appear to address its mind to this question.
I think the Tribunal findings are capable of supporting both conclusions, because the Tribunal is looking at this. Obviously, they've got their independent expertise as well from the two Tribunal members, and so they're looking at this, and they are first of all, they're looking at a process that would have identified uncommercially low rates of interest, by which the authority is not getting a good return for its investment. And that's what the Gateway Panel and Credit Committee, that's why they have independent expertise, private sector expertise, to identify those issues. So the Tribunal is taking the view that, in the words of 202, the Tribunal is satisfied that the GMCA could reasonably conclude that there was no subsidy.
But they also say a few lines further up, it is evident that the GMCA did not have any doubt whether the lending infringed the CMO principles. That seems to be a finding that the GMCA was satisfied that the lending didn't infringe CMO principles.
But that's why I answered my Lord Justice Smart's questions by saying with both of his propositions.
Yes, I see.
Yeah.
So that's...
and you say that the tribunal was entitled to come to that conclusion despite the fact that so far as the March meeting was concerned, nothing was put before the GMCA itself which addressed the question of CMO, and nor have we seen anything from the minutes of the Gateway Panel of the Credit Committee which in terms addresses CMO. But you say, taking the process as a whole, it wouldn't have got to a stage of being recommended for approval, if there had been any doubt about it.
Yes. So they wouldn't have made a recommendation to the authority to proceed with this on the basis that they had doubts as to whether this was a commercial loan or not. They've satisfied themselves that these are commercial terms. That's what they're there to do. And therefore it can go to the authority. The authority doesn't have to address at that point whether this is a subsidy or not, because it's a commercial loan proposition. It's commercial investment by the authority.
Which suggests that the extent of the consideration they gave to this was, in general terms, is this lending on commercial terms?
Yes.
They didn't. There's no evidence and no finding that they also went on to think there's this statutory question that we have to address, namely whether this is a subsidy. Having reached our conclusions on commercial terms, are we satisfied it satisfies that test? They didn't do that second step.
I can't point to a minute that says that they did that step, but this is lending from a fund that has previously invested on 8 occasions with this developer on the basis that these are commercial investments and comply with the state aid rules.
Well, we've no evidence that they ever considered, have we, that the other loans comply with state aid rules?
No, there isn't any evidence about that. We just know that there have been 8 previous loans, and they say we've got a good history of lending to Renaker for these types of developments. We've done so on 8 previous occasions. Yeah. And there's nobody's identified there being any issue with compliance with the state aid rules or the subsidy control rules.
As I understand your submission, then, is that the GMCA was of the view this was commercial lending because that's what they were there to do. Yeah. This was on commercial terms, and the tribunal's finding is, well, given that they reached that conclusion, actually there would have been no doubt as to whether they needed this comply with the subsidy requirements, yes, the CMO test. And paragraph 15.57 of the guidance says all these things that you should do only apply if you're in doubt.
Yes.
So they, in fact, did not infringe the guidance, or they did not fail to comply with the guidance because the guidance didn't require them to do anything else given their starting point. That's your submission, I think.
So that's ground 4. Then ground 2, from a learned friend yesterday, is his grounds 5 and 6 run together. So ground 5 is the CAT wrongly refused to apply the reference rate communication. And this is the 4% point.
I'm sorry, I missed the ground number, just to keep it anchored.
So this is his ground 5.
Yeah, thank you.
And I've summarised it as the CAT wrongly refused to apply the reference rate communication to require the application of a 4% uplift. The tribunal's assessment of interest rates starts at paragraph 185 of the judgment, and that's on page 138. This begins at paragraph 185, 138. The process followed by the respondent in reaching the subsidy decision, and thereafter, after entering into the Renaker lanes, appears the tribunal to be a perfectly rational one and not inherently defective. It then specifically addresses the reference rate communication. So there was a lot of detail we've already covered at paragraphs 186 through to 194 on page 144. Repeat those, but that's the tribunal's assessment that this the approach taken by the authority seems reasonable and not effective. It then looks at reference rate communication beginning on, well, the section begins at paragraph 195 and 144 under the heading, did the analysis in the RSP fail to comply with guidance on reference rate communication? And reference rate communications starts at paragraph 198. So it dealt with the IRSP at 196, 197. They took the 2022 regulations. That was they weren't used as the basis for pricing the loans. They would have given a figure that was too low. More significant, this is paragraph 198. More significant is the analysis under the reference rate communication. Whilst the reference rate communication is an EU provision, and the UK has long since left the EU, the tribunal considers it to be a useful cross-check. The RSP was right to consider this communication, was entitled to do so without being strictly bound to follow it blindly. The key contentious point is whether the GMCA should have added a minimum 4% over the base rate for the fact that the lending was to SPVs. The relevant part of reference rate communication provides for borrowers that do not have as credit history or a rating based on a balance sheet approach, such as with certain SPVs. Base rate should be increased by at least 400 basis points, depending on available collateral, and the margin should never be lower than the one which would be available to the parent company. The tribunal does not consider that under the reference rate communication, any time there is an SPV as a borrower, there must be an automatic 4% the base rate. There's a degree of inflexibility inherent in the reference, in brackets, to depending on available collateral. In the present case, there's substantial collateral as well as protected conditions. It's not suggested by either party that Mr. Walmsley and the GMCA were unaware of this part of the reference rate communication. Initially, Mr. Walmsley looked at the position of XQ Developments, which had a net worth, so that's the SPV that was wholly owned by Mr. Walmsley, which had a net worth of £321 million and a very low risk rating of 5A1 from Dun & Bradstreet. By the time the 2024 Renaker loans were entered into, that company had gone into voluntary liquidation. It did so in October 2024, and its very substantial assets were to be transferred to Mr. Whittaker as a shareholder, or as its shareholder. It was a condition of drawdown that the equity contribution of Mr. Whittaker must have been in place. So if he did not make the contribution, no lending would take place. Given the level of collateral, low loan-to-values, valuations, and the substantial security, Mr. Walmsley was entitled to take a view that it wasn't necessary or required for 4% to be added over the base rate as a minimum. The tribunal considers that this was a reasonable approach, and other lenders in the commercial field would have been entitled to take the same approach in assessing the impact on margin of the fact that the borrowers were both SPVs. Mr. Whittaker evidently had access to very substantial amounts of funds as a result of the liquidation and execute developments. That said, it would have been better had the GMCA obtained a statement of its assets and liabilities prior to entering into the 2024 loans. There was a residual, although most probably unlikely, risk that he had large liabilities which could have been wiped out, which could have wiped out these funds. But as the equity had to be in place at the time of drawdown, the GMCA had substantial protection against the consequences of such an eventuality. So that's how the tribunal dealt with the applicability of the reference rate communication, why the automatic 4% added to the base rate wasn't a rational, it was rational not to do that. So we say simply in reference rate communication, the tribunal was right for the reasons it gave.
That doesn't deal with the construction argument, does it?
Vis-a-vis the government.
No, the construction of the reference rate communication. And the point that was taken was whether the margin had to be at least 4%. And the tribunal seems to have thought that depending on the available collateral, the words depending on the available collateral meant that it could be less than 4%.
Yes. So if all the equity has gone in, then these SPVs are very well funded.
But what's the answer on the... I'm asking a point about the interpretation of the document.
On that specific point, we had provided to the tribunal below an extract from Bacon's Law of State Aid. It's the textbook which is authored by now the President of the Competition Appeal Tribunal, Mrs. Justice Bacon. It's published in 2017. And in the extract from that textbook, it's explained that the reference rate communication is a starting point, but you may go up, you may go down. And authority is cited for that in the textbook, and the tribunal asked us to provide the underlying authority, which we did. So our submission was that it isn't a strict rule never to be departed from. It's only a starting point. And the tribunal has, in substance, accepted that.
But that's not the way it was dealt with here. It wasn't said, oh, it's just a starting point, we're going to move away from it. As I understand it, the paper was saying, we are applying the reference rate based on the reference rate communication paper. It didn't say, well, we acknowledge that, but we're going to depart from it. It said, this is in accordance with the matrix. That's what I understand it was saying.
Yes, but not applying the 4%.
Sorry?
But deciding not to apply the 4%.
Yeah, but how do you get that? What's the tribunal seems to say that that was not irrational, because it says there's a degree of flexibility inherent in the reference, in brackets, to depending on available collateral, which is, and this seems to be a point about interpretation of the reference rate communication. And the point that's put against you on this aspect is that that's not the right reading of those words. It's saying that it's got to be at least 4% and maybe higher depending on the available collateral.
And our submission to the tribunal was you do not automatically apply 4%. The case law says that it's a starting point and may go up or may go down. And the tribunal in paragraph 198 says the tribunal does not consider that under the reference rate communication, any time there is an SPV as a borrower, there must be an automatic 4%.
Well, that's a point about interpretation.
Yes.
I'm sorry, I feel I'm repeating myself, but that's a point about the interpretation of the communication, not a point about saying that you don't have to, that the matrix is not a strict binding rule. It's a point about the meaning of the rule.
Well, it's how the rule is applied, and our submission was, and still is, that the tribunal, and indeed the authority, is free to depart from that, and is not bound to apply it slavishly.
When you look at Mr. Walmsley's paper, he seems to take the view that in terms of the matrix, the collateralization is high, so you're looking at the left-hand column, and the creditworthiness is satisfactory, and therefore that produces a figure of 100. Is that reasoning which you support? Were these SPVs capable of being regarded as having a satisfactory rating? Because I think my note was that Mr. Barrett told us it was common ground that actually they should have been the lowest of the rating category.
Well, the fact that they were SPVs it didn't create a risk that justified the application of a 4% uplift. You could take the view, and the authority did, that the various elements going into the funding meant that there was still a relatively low risk proposition, not least because they had to be funded with equity before any element of the loan could be drawn down.
So you're not really lending on the covenant at all? Because the covenant of an SPV, which is limited to the value of its assets, and if it doesn't have any assets other than what you're lending on, then it's the value of the asset you're lending on.
Well, what the tribunal says about this is on page 142, to do with the covenant point.
Right.
142, it's the paragraph 193, which begins on 141. And the tribunal goes through the various elements or the terms of the loans. And we see subparagraph 1, the rates are not obviously low. The subparagraph 2, the LTV, LTC ratios are low, which substantially reduce the risk of any default. And then the point you're making about covenants. Covenants and conditions for drawdown, this is the point I was seeking to make, substantially protected the respondent from the risk of default or shortfall. On the Trinity loan, the development had at the time of November 2024 already been the subject of a forward sale agreement by the term of the loan, which substantially reduced the level of risk. They'd sold it on to an investor in the private rental sector. And then 3B on page 143 was condition of drawdown that the borrower's equity was provided with funds. And this was on a subordinated basis, meaning that the respondent, the authority, had priority on default to recover its lending. In effect, if the SPVs were not creditworthy, there would have been no drawdown. Then C, contour, covenant of the total facility amount for it would be covered by exchange sales at the point of first drawdown. And then they then go on to point out that other security for the loans was substantial, which itemised as A to E. And then they expressed the view at subparagraph 5, there wasn't a personal guarantee for Mr. Weis or any debentures and other Renaker Group companies. This was relevant to pricing, but would not have justified any significant increase in rates in all the circumstances. That's what the tribunal found. I think that's, I can't answer the question more than that.
Okay. I'm still left a little bit unclear as to whether the tribunal thought that the creditworthiness of these borrowers in terms of the matrix was satisfactory, which would justify 100 basis points, or that although it wasn't satisfactory, you could depart from the 400 basis points which the matrix produces. Because they seem to, well, they're saying both.
I think they may be saying both.
But the two are two different ways of getting to this particular interest rate.
Yes.
My Lord, I think I should rise on that. My position is it was common ground that it was the latter.
Yes.
And if our friend wants to dispute that, I think he needs to make it good.
That's what I understood you to say, yes.
Just on that point, can I just point out that in 198, the tribunal says the key contentious point is whether they should have added the 4% for the fact that lending was to SPVs. And then they go on and quote the relevant bit. And then their reasoning seems to be that the bit in brackets which said depending on the available collateral imports a degree of flexibility so that even where those words apply, you can select less than 400 basis points depending on the available collateral. That seems to be their reasoning. And the challenge to that is that that's not what those words mean.
And as I said, the authority that we submitted below was that the reference rate communication isn't binding. I mean, it's only a commission notice. It's not a binding rule of law.
But that's a different point.
Yeah, but then when one interprets it, as a matter of law, there is authority that says that it's just a starting point and you may depart from it. And that's what the tribunal has done. And indeed, we've just been through the various elements that the tribunal identified as being relevant to their view that this was a relatively low value proposition, a low risk proposition.
Can you help with what's meant by a rating based on a balance sheet approach? First of all, does that mean an SPV which in fact has not got a rating from any rating agency, it falls within this category of 400 basis points to be added? I'm just looking at the reference rate communication itself.
I think I'm afraid the straightforward answer is I don't think I can assist you with that. We went into what case law there was on the reference rate communication, and essentially it is, as I've described to my Lord Justice Miles, it's extract from Mrs. Justice Bacon's textbook and the authorities she cites, which were provided to the tribunal. They asked to see them. But beyond that, there isn't European authority.
Well, it's not so much I'm not sure it's an authority question. It's a question of what's meant by a rating based on a balance sheet approach, because it goes on to certain special purpose companies called startup companies. Now, this SPV would have had a very substantial balance sheet, given it owned the site and had the equity injection from Mr. Whitaker. So I just wonder if none of that was considered.
No, it wasn't. I mean, it's a commission communication. They may be thinking within the commission, but that's not made it, so far as our research has showed, into print. The second element of Will and Friend's second ground, which was ground 6, essentially the margin was too low. Well, I've already covered that actually by taking you to the passage set out at paragraph 193, where the tribunal sets out its reasoning as to why the margin was a reasonable margin to adopt, and I don't think I can really say more than we support what the Commission, what the Tribunal has to say on that in relation to ground 6. That takes me to Mullin and Friend's third ground yesterday, where he swept up grounds 1, 2 and 3 together. The first point is, and this is his original ground 1, that the Tribunal erred in failing to apply orthodox judicial review principles to review the lawfulness of the decision of the 22nd of March. And on that, I think the starting point essentially is paragraph 153 of the Tribunal's judgment on page 131. Where the Tribunal correctly stated, in determining the key issue, in this case, as to whether the loans amount to financial assistance, which confers an economic advantage, the Tribunal does not simply look at the terms of the decision of the 22nd of March, it needs to consider the whole process. Then it then sets out, as we've seen, after the parties' contentions, an analysis starting at paragraph 184. On page 138, and in particular paragraph 185, the process followed by the respondent appears to be a perfectly rational one and not inherently defective. We already covered that. So it's applying orthodox judicial review principles and to reach that conclusion. More generally, and the argument that there should be some sort of freestanding judicial review of the authority going beyond the subsidy decision powers conferred upon the Tribunal. We covered that yesterday. We don't say, we submit it wasn't an error of law for the Tribunal to consider the whole process as contrasted to Mullin Friend's case, which is that they should effectively only consider the authority's decision of the 22nd of March. The second ground related to the IRSP, the Tribunal referring to that, and we've already covered that this morning as to what the Tribunal got from the IRSP, and I don't think I've got anything further to add on that. And then the ground 3 was that the GMCA should have been provided with a specific paper on the interest rate to be charged on the proposed loans. And by that I think he means a specific paper on compliance with section 3, subsection 2. And again, we have already covered that this morning, the process of the Gateway Panel and the Credit Committee, and then putting the loan propositions to the authority. It didn't need to have a separate paper explaining why Section 3.2 applied. In terms of my learned friend's case, that rationality also required evidence of actual competing offers of funding from other commercial investors. In other words, a comparison with actual alternative funding offers. On that point, we've already considered Sky Blue Sports and Bulb Energy. We had that discussion yesterday. There's just one additional authority to draw to the court's attention. That's in the authorities bundle at tab 19. And this is the new lottery company case in the CAT. And the reason why it's not referred to in the tribunal judgment, it wasn't referred to the tribunal, was that this wasn't handed down until the 26th of February this year. And so it's authorities bundle, tab 19. It starts on page 590. And you'll see there the discussion of the CMO principle commences on page 590, paragraph 67, where the tribunal, as I say, chaired by Mrs. Justice Bacon, discussed the CMO principle being a creature of the Subsidy Control Act. The tribunal then goes on to discuss the relevance of EU case law to the CMO principle. That's paragraphs 69, 70, referring to Sky Blue Sports and Bulb Energy. Sky Blue Sports, obviously, under the state aid rules. I mean, Sky Blue Sports, by the way, yesterday, my learned friend said, "Oh, look at Sky Blue Sports. They've got other grounds of just general public law challenges." Yes, it was a judicial review. It wasn't a CAT case under the limited jurisdiction under the Subsidy Control Act. So you could bring in other judicial review challenges, and of course it needed permission to proceed. So Bulb Energy, which is a judicial review under the interim regime, so that's a TCA regime, but EU law continues to be relevant through Sky Blue Sports. And there, on paragraph 72, the tribunal explains that the CMO principle doesn't involve a departure from MEOP and MEEP. Under EU law, if that were the case, you'd have expected it to be made clear in the SCA itself or in the statutory guidance. There's nothing to indicate, as I said yesterday, that it's a radical departure. It's the same underlying concept. So the additional passage. So the tribunal discusses the test under the CMO principle from 592 through to 599, and in particular, and this is the point I just wanted to draw to the court's attention, is paragraph 91. We reject the applicant's contention in that case that the market economy operator principle, and by analogy the CMO principle, should not apply in circumstances where there is no actual market comparator. As there wasn't in that case, it's dealing with the national lottery. The question that must be asked in such a case is whether the state intervention is assimilated to or is comparable to that of a private operator. If so, the correct approach is then to assess what the normal market conditions might be for provision of relevant benefit on the basis of the objective and verifiable evidence available. And that's a position, paragraph 2 is consistent with section 3 of the Subsidy Control Act. So not only was there no need to go out and look at rival offers in the market, section 3.2, there was no need for a separate paper to the meeting. The final ground is...
Sorry, I'm just trying to see what the tribunal did about the question whether the decision was a subsidy.
They came to the conclusion it wasn't a subsidy.
Sorry?
They came to the conclusion it wasn't a subsidy.
And did so entirely, as it were, de novo, right? It wasn't a question of reviewing anybody else's decision. It reached the decision that it wasn't a subsidy.
Yes.
So, on Mr. Barrett's case, that must be wrong. Yes, yeah.
And it seems from paragraph 94 that the respondent agreed it didn't actually consider the subsidy control principles because it didn't consider that the decision amounted to a subsidy.
Yes.
But
so the fourth and final ground advanced yesterday by my learned friend is his ground 7. And that's submissions based on the Maslow loans, concentration risk, and a comparison with Mr. Whittaker's representations in FBAs as to affordable housing. Just to deal with those points very quickly, the Maslow loan, that was dealt with by the tribunal in paragraph 191, where the tribunal said, first of all refers, so there's page 140, 191, refers to the club loans, which I've already mentioned, the Addison-Young independent analysis, and there seem to be in line with the lending market. The loans were therefore priced based on the previous market rate lending, but amended to factor in the differences between these loans and these loans. Namely, that these, the Renaker loans in question here, were lower risk to the GMCA and GMCA's perception of the market. The appellant contends that the Maslow loan, Pound Street, would have been a better comparator, or at least should be taken into account, and this was a higher rate of interest. It does not appear that this loan, which was not with the GMCA, was taken into account, but from the description of its terms, security and ratios, as explained in an email from Mr. Whittaker, exhibited by Ms. Blakey, it would not have been a particularly helpful comparator in any event. It's just a classic example. We've looked at your argument, we've looked at what evidence we've got, and we've come to the view that the club loans, the Collier's Yard and the Blade, are just better comparators. That's not an error of law. Concentration risk, that is at paragraph 201, and that is on page 147. The other main criticism of the lending was in relation to concentration of risk. You know, a substantial percentage of the fund was being or had been advanced to entities within the Renaker Group. The significance of this point would depend to a large extent on what other prudent lending opportunities there were, the level of risk and default and shortfall, and how much would be outstanding at any one time from entities within the Renaker Group. There's no evidence to suggest that lending to the Renaker Group squeezed out other prudent lending to other developers. We've already concluded that 2024 Renaker loans pose no more than minimum or low level of risk. Here the concentration risk was limited by the existence of the cap on total monies that could be drawn down at any one time by the Renaker Group, 120 million. the tribunal does not consider the level of concentration at the time of the entry of the judgment for Renaker loans renders the loans uncommercial within the section 2.2. The Renaker Group had a good track record in their history as well. And the GOC had in the past approved loans in excess of £30 million to others, to other developers. So the tribunal considered it and rejected it, and we say they were well within their rights to do so. The final point relates to this point about FVAs, which is paragraph 2. It's dealt with at 216 on page 153, and Muller and Friends case as well. Mr. Whitaker was saying one thing in relation to the FVAs presented to Manchester City Council, and another thing to the GMCA. They simply rejected that, having regard to the Red Book valuations that have been carried out as part of the due diligence process, and incorporated, amongst other things, a property risk analysis. These are far more helpful than the FVAs. The GMCA was not obliged to consider the FVAs. So again, it's just, we've considered your evidence. We think it's outweighed by other evidence as to what the authority did. And that's just classic assessment of evidence and not grounds for any error of law. So that's what I wanted to say about Muller and Friends grounds. I said I would conclude by dealing with remedies. So if Muller and Friend does succeed in part or in whole in his appeal, what then happens? Muller and Friend suggested that that would lead to a draconian remedy of quashing and repayment of the loans. It wouldn't, in our submission. If the tribunal, if the court were to find that the tribunal had misdirected itself in law, it could remit to the tribunal for reconsideration. If another alternative would be that the authority would have to carry out an assessment of the loans compatibility, if there were subsidies, with the subsidy control principles, and if appropriate, to make a notification to the Competition and Markets Authority under the provision that I referred to yesterday. Any remedy, therefore, would be declaratory only. There would be no need to quash an order of repayment, even assuming the court had such powers. I've already dealt with the point that 2/3 of the loans have been drawn down in any event as construction of the towers proceeds, and the fund closed in March 2025 and is now proceeding through run-off and closure in March 2028. The funds are due to be repaid. These loans are due to be repaid by March 2027. One other postscript, and that's to just address the authority that I handed up yesterday, Thomas and Durham County Council, and it's just simply for information only. This is a judgment that was handed down on Friday by the CAT, again chaired by Mrs. Justice Bacon in a subsidy control case. She doubts that this tribunal was right in relation to the timing as to when a challenge may be brought under Section 70. And those doubts are expressed in that judgment. You'll note at paragraphs 84 through to 100. This isn't an issue in this case. That's why there's no respondent's notice. I'm just drawing the court's attention to this so that you are aware of this very recent judgment, which does touch upon one aspect of this judgment which is not under appeal.
So you accept, for the purposes of this appeal, that the decision of the GCMA is the March 24 decision, but you invite us to look at that decision against the whole background of the process you've taken us through.
We accept that that was a decision, Our case is that actually the final decision, the legal right to financial assistance didn't arise until the 22nd of November 2024. And therefore, that's the point at which the subsidy decision was adopted and time started running for bringing a challenge under the Act. That's been our position below and it continues to be our position.
It is. Sorry, you're not appealing the finding of the tribunal that was not right. They rejected that.
No, we're not. We haven't.
It doesn't really matter what your position was.
I just wanted
It's a question whether you've appealed it.
Yeah,
which you haven't.
We haven't. Yes. So I just wanted to put that position clear that what the authority's position is. Appreciate that it's not a point that's been appealed.
So for the purposes of this appeal, we are looking at the March 24 decision.
In the context of the whole decision-making process.
Yes, as you took us through.
Yes. Which is what the tribunal did.
Well, thank you very much.
Back on 12:30 as well.
And well timed, yes. Yes, despite us lopping off 5 minutes at the start. Yes. Mr. Barrett.
Thank you very much. Could I begin, please, responding, just picking up the last 2 points my learned friend dealt with at the end of his submissions. I would invite you to put Thomas out of your mind. There hasn't been a respondent's notice. Handing it up is an attempt to muddy the waters, confuse you as to what...
Well, it's helpful for us to be informed as to what has happened, but no submission on the basis of it is advanced. No. It's quite clear that that point has not been appealed.
And if I may, my Lord, I'd add another point to that, which is, with all due respect to the judge in Thomas, she obviously did not have access to the evidence, the actual documentary evidence in this case. And so the views she's expressing about the decision-making process, how it actually worked, in my respectful submission, have to be treated with very considerable caution. Yes. She's simply not, in all due genuine respect to her, it's not something that can be given weight in my respectful submission when that judge hasn't seen any of the evidence. Second point, my Lords, then, my learned friend said that I had taken the position that if any ground of claim succeeded, there would be draconian relief of quashing. I hope it's clear that is not my...
You said it would be sent back and it could be argued about.
As my Lord put it to me, a position I'd be very happy to reach if I did. So no part of my submission. Can I then just try and clarify what I fear is confusion that is arising as to the factual structure of the decision-making exercise? It is common ground, as my Lord Justice Miles pointed out, there is a finding. There was no material before the decision-maker other than the Part B report. Mr. Walmsley's paper never went to any decision-maker or any of the relevant committees, and there is no evidence as to the basis of the content of Mr. Walmsley's paper other than the document I referred you to. I gave you the reference in the unagreed bundle at tab 26, the date stamp, which tells us definitively that he sat down and started writing it 3 days after the authority received the pre-action letter, after the decision maker made its decision. In those circumstances, on any conventional legal analysis as a matter of public law, it is inadmissible and irrelevant for the purposes of the court's judicial review function. I just want to be as clear as I can about that. My Lords, could I just deal very quickly with what I would characterise as my learned friend's prejudice points? Primary schools, I would invite you to put those out of your mind. They're not part of this case. Very considerable experience and expertise. What the evidence shows very clearly is that that experience and expertise in relation to substantial loans consists of making loans to SPVs controlled by Mr. Whittaker. That is the extent of the expertise and experience. My learned friend was also very keen...
Sorry, I don't understand that. The expertise relied on was people from outside.
I think the way it was put by my learned friend is he relies, I think he says, on Mr. Walmsley and his colleagues. He says they're very experienced chaps, they've been doing this for a long time, they know what they're doing. My response to that is the evidence makes clear, in terms of loans of any substance, any high values that this fund has lent, they're all to Renaker.
No, I understood his submission to be these are people who've worked in industry,
yes,
RBS for 30 years.
So I think he does make that point, Malone. I think he makes both points, okay, if I may say so. may I deal with that point, please, then moving on to the committees? Well, that's why I referred you to the minutes. The minutes are the record of what was considered and discussed. My learned friend submitted to you that the minutes only record action points. I would just invite you to read the minutes. That is not true. They record points that were considered and discussed in the conventional way. There is no witness evidence suggesting that the minutes are incomplete or inaccurate, and there is no witness evidence from any of the independent people who were on any of those committees.
So what's your point? There's no reference in the minutes to the external advisors piping up.
Of giving any consideration whatsoever, I'm about to come on to this, whatsoever, to whether the loans are on market rates. No consideration whatsoever, and no evidence before them to help them consider that matter. Now, I say, my lords, that the explanation for that is perfectly apparent. The explanation for that is that we had this unminuted negotiation between Mr. Innovolson and Mr. Whittaker. Mr. Innovolson was a very senior person, and he was sitting in those meetings, having agreed with Mr. Whittaker before the meetings, as Mr. Whittaker specifically wanted him to do. That is the obvious common sense explanation as to why these matters aren't being thought about and analysed.
The fact that there's that negotiation at that stage doesn't really throw any light, does it, on whether they were in fact market rates. It's just
on one level,
the time it's just the way it was done.
I mean, on one level, my lord, I think I would be bound to accept that in the sense that it's perfectly possible as a matter of principle that what Mr. Innovolson and Mr. Whittaker sit down and agree turns out to be market rate. I don't think I can dispute that proposition as being a possibility. What I say simply is there was none of the consideration, none of the analysis that I say, both the statutory guidance and basic public law principle says needs to happen in formulating that rate. Yes, and now Junior quite rightly reminds me, we are in the context of this case in a particular scenario where there are just these hard-edged legal obligations pursuant to the facility agreement, pursuant to the investment policy, for the particular process that needs to be followed. So we do say, as I say, my lord, at one level I can't dispute the proposition that it's possible that the outturn turns out to be a market rate, but we say that is not lawfully good enough.
Can I just ask you this question?
Of course.
Supposing, just on this committee's point and the expertise and so on, if you just assume with me for a moment, you might quibble with some of the terms of this, but assume that the background understanding of everyone is that this fund is not to be used to make subsidies.
Yes.
It's to be used to make.
Which I think I need to accept.
Right. The people on the GMAC know that there have been various steps beforehand. They know about the investment team. They know about.
I don't think I can dispute that they know
the two committees. They know about the process. They know that those people include people with lots of experience of commercial lending. No one actually sits down and says, this is not a subsidy. There's no document which says that. There's no document that says this is all at market rate. But is it not possible for the members of the GMCA, sorry, I keep getting wrong, GMCA, to operate when they're making their decision on the reasonable assumption that the rates are market rates, against all of that background?
Yeah. So what my lord's just put to me, my respectful submission must be the case against me. What my lord's put to me is they haven't been given a shred of advice, they haven't been given a shred of paper, a paragraph or a sentence. It is lawfully good enough if they are simply aware that there are some other people or processes, and if I could emphasise this, I say this is the correct analysis for the purposes of your question, who are supposed to think about these things. And I say that's not lawfully good enough.
Not just supposed to think about them, but they themselves are working in order to agree a commercial loan with them.
Yeah. So my lord, this comes up in all sorts of public law contexts. What you're putting to me is it good enough that everyone understands and intends that you're supposed to reach, and you're trying to reach, as it were, a lawful result? No, it's not. There must be a lawful process of consideration. There must be some advice to the decision maker. I mean, to be crystal clear, And my learned friend said, my position is, or my case is, that they needed another report. That's a load of nonsense. They didn't need another report. They needed a couple of paragraphs giving them the essence of the point. Here is why this is a market rate. Here is why this does comply with our important legal obligations pursuant to the facility agreement, pursuant to the reference rate communication, pursuant to the statutory guidance. And this is done up and down the country, day in, day out, by local authorities, including with transactions far lower values than this set of loans. So, my lord, I understand the point you're putting me. I say it's not good enough. I say that's what Stratford shows you. That's what Kenyon shows you. I could give you another 20 authorities that show you the same thing in my respectful submission. My lords, could I turn then? Pardon me, I'm terribly sorry. There was one further point I just wanted to make on the evidence about the RSP, Mr. Walmsley's paper. My learned friend was very keen. He said, I think 3 or 4 times, this is a standard part of the process. Could I just make clear that you understand the evidence about the IRSP? The authority's witness evidence for the trial on the process is the first witness statement of Miss Blakey. She sets out, it's a long witness statement, I invite you to read it. She describes blow by blow the process that applies to the giving of loans under this fund, and she does not mention once an interest rate setting paper. So that was the authority's evidence for the trial. What then happens is Mr. Walmsley's witness statement comes in after the trial, and in Mr. Walmsley's witness statement there is a paragraph which says the IRSP is a standard part of the process. So there's only so far I can take that. It's a judicial review and you've got witness statements, but I just want you to understand that is the evidential picture, that was the position.
But it's also something that the CAT found, because they seem to have accepted.
They accepted that post-trial witness statement. I'm stuck with that, my lord, yes. So, my lords, please could I then turn to the grounds. I'm not going to repeat I don't have time, and I suspect you won't be assisted. I'm just going to seek to deal with what my learned friend has said today, and also some of the points my lords have raised. Can I start then with failure to have regard to the statutory guidance? First point, my lords, I think that the case that my learned friend now seeks to put to you is not open to him. My learned friend accepted below that there was an obligation on the authority to have regard to and apply, subject to good reason to depart, from the statutory guidance. His position before the tribunal was that there was no provision within the guidance which was relevant to the present case. He said there was no provision in the guidance that created or directed that there should be a process of consideration whether or not the loans did or didn't comply with section 332. So the case he seeks to run now, I say, is not open to him. He didn't run it below, there was no respondent's notice. On the substance, my lords, I say it's a case, as advanced this morning, that doesn't work. As I understood it, what he put to you was that you should proceed on the basis that the authority had no doubt, I think he said, that the rates were consistent with market rates, and therefore there was no need to read the statutory guidance. That would turn statutory guidance, the obligation to have regard to it, on its head as a matter of logic. Secondly, it's obviously not supportable by reference to the facts. Mr. Walmsley has a 12-page paper analysing his view on whether loans are or aren't consistent with market rates. It's not the real world, in my respectful submission, to suggest that it is the case, or that anyone thought it was the case, that there was no need to think about this point. So I do say, my lords, my reference hasn't really answered, I say, this case. There doesn't seem to be any dispute that no one has ever, in this case, looked at the guidance, read the guidance, thought about the guidance. And what I say, my lords, is, I'm not going to repeat all my submissions about it being an important document. I say it must be realistic that if the guidance had been considered as it should have been considered, more and better analysis would have been done to ensure that these loans were being granted on a market rate. The guidance is extremely helpful. That's why the Secretary of State has promulgated it, and it leads to better decisions.
What do you say about the point that if it's right, the GMCA itself just considered these were market rates, and therefore there wasn't an issue about this. Let's assume they didn't think of the guidance, didn't look at it.
Yes.
But had they done so,
I say that doesn't discharge you.
Than that.
Yes, I say that doesn't discharge you from the obligation to have regard. I mean, if I could just give you an example, in order to illustrate my position. Of course, one might take the view that this is absolutely fine. I have no concern about market rates. You might be doing that on a completely inadequate basis or a misdirected basis. I would obviously say that is this case. But in terms of the operation of either the public law obligation to have regard to guidance or Section 79, the law doesn't operate on the basis that because a public authority thinks it knows better or doesn't need to worry about something, it doesn't need to think about the guidance. It needs to look at the guidance, consider it lawfully. If it then wants to do something different, then if it makes a rational decision to do so, that's okay. But it can't simply put its head in the sand, in my respectful submission. Can I turn then to the grounds in relation to the failure to apply lawfully the reference rate communication?
May I just ask you a question before you do that? Supposing that the approach taken in which is illustrated by the lottery decision, which we're taken to,
yes,
is right. Just suppose that.
Which I'm going to come on to deal with, or I'm going to try and deal with that.
Sure, but it may be helpful just on this point, if we may, just to isolate it. So that the question of whether it's a subsidy at all is what's called an objective question. Yes. And suppose you're stuck with a finding of the CAT that this was not a subsidy. Yeah. But you've still got your argument under Section 79, and you say there was a failure to comply with to have regard to the guidance. How does that then all fit together? What's the outcome in that case?
Of course. So Lord, my submission, very short answer. They're separate complaints, separate grounds of claim. I say the correct analysis is that it would have been open to my learned friend to submit as part of his case in response to my failure to have regard ground, that on these facts it just made not a blind bit of difference.
So this is the no difference point.
This is the no difference point.
And then you say they didn't raise that.
It's never run, no such argument advanced, but that would be the answer that one would be advancing in principle.
And if, given that there is no difference point being run here, what then is the upshot in practical terms,
real world terms,
real world? What would
I've got to be careful
anyone do about it?
I've got to be careful what I say, my lord, because my client will obviously have an interest in pressing as hard as we can if and when one reached relief. But the point my lord's putting to me, I think you're putting to me, would you not have difficulty pressing for certain types of relief? And as I say, I've got to be careful what I say, my lord, but I certainly understand my lord's point. I think it's probably as far as I can properly take it.
All right. Thank you.
So could I deal with the failure to lawfully apply the guidance? I mean, I do say the exchanges my other friend had with you, I do say are helpful. My other friend hasn't advanced an answer to the construction argument. He's been given every opportunity to do so. I invite you to accept what we say about that. I say it does follow from that there has been a misdirection, a failure lawfully to apply the document in accordance with its terms. The point my other friend repeatedly reverted to the fact that it's not, as it were, binding or definitive as a matter of EU state aid law. I dealt with that in my submissions. I'm not going to repeat them. That is a different point. Doesn't help on this issue.
I'm sorry to keep asking questions, but this is another question. On page 142 of the tribunal's decision,
yes,
they do a comparison of, well, they come up with what they call effective annual rates for the two loans by annualising the 1%
yes,
arrangement fee, so that's separate from the loan management fee. And that gives you 9.7.
I think, my lord, should we be reading that? I'm sorry, my lord, to interrupt you. I'm terribly sorry. Should we be reading these out? I'm just wondering. I haven't got up with you. Are they highlighted?
I'm so sorry. Over those bits.
Those are said to be confidential. We don't necessarily accept that, but they're said to be confidential.
All right, I'm sorry. Right, okay, well, without reading out the numbers, the point is that if you include the annualised arrangement fee on the Trinity loan, and then you compare that, the total, if you added 4% to the base rate, would be 9.65.
Yes.
On the contour, if you include the 1%, it's... Well, we can see what it is.
Yeah, so I think it's more putting to me, does that make it okay because you're adding the arrangement fee?
Yeah, would you agree with that way of analysing?
No, I wouldn't at all. And it's the point my Lord's mentioned a couple of times. When one actually understands the function of the facility agreement and the mechanism, the arrangement fee, as it were, is going into the pocket of the authority. So it's not curing the failure lawfully to apply the process that's set out in the reference rate communication and the facility agreement for that reason. I also say it is also a separate matter. Arrangement fees are a separate commercial matter in financing agreements. They're not something, as it were, that are being dealt with in the reference rate communication. So I say the fact that there's also an arrangement fee, as there not always but often will be, I say it doesn't assist the authority in any way with its failure lawfully to apply the reference rate communication. Can I deal with the second part of my case in relation to this? Again, I do see my learned friend hasn't addressed my case. He focused very much on the tribunal's reasoning, where the tribunal had some reasoning to the effect that because of the equity going in, because of the security arrangements, that might provide a lawful or rational basis for saying we're not going to apply 4%, we're only going to apply 1%. I showed you, my lords, and I hope you will look at it, the Mr. Walmsley paper. That was simply no part of his reasoning at all for his decision to apply 1% rather than 4%. The reasons for his decision are entirely clearly stated on the page. It's because there is an ultimate beneficial owner, Mr. Whittaker, who he assumes has substantial assets. That's the reasoning of Mr. Walmsley. And that reasoning, in my respectful submission, for the reasons I explained, is not rational to effect a reduction on that basis in circumstances where there is no recourse against Mr. Walmsley. You do not, my Lord Justice Nugee's point, you do not have any access to his financial covenant at all in any circumstances. And you do not know, because you have not even thought about it, what his true financial position, creditworthiness is. It's not rational. My Lords, could I turn then to... Just give me one moment, sorry. Could I deal please with my grounds 1, 2, 3, and could I begin with what I say is a short point now following my learned friend's submissions. You will recall, I hope, that I submitted to you that even if I was wrong regarding the standard of review to be applied under section 3.2, the tribunal still erred, and the appeal should still be allowed, because pursuant to the proper application of the market economy investor principle, the court, while making an objective analysis, is still doing that on the basis of the information at the date of the decision. That was paragraph 73, note 75.2 of the TNLC judgment. My friend went to TNLC, but he did not deal with that passage.
That doesn't necessarily mean the information available to the public authority.
So my respectful submission, it does, my lord, because what the Meek principle is doing, this will take a little bit of explanation, what the Meek principle is doing is saying, right, the authority is making the decision at this date. We are objectively considering what would a similarly situated market economy investor principle sitting there at that date with that information do. So it's not different in my respectful submission. One is still looking at the date of the decision, the information that's available at the decision. That is 75.2 of TNLC. That is, in my respectful submission, the principle. And my learned friend didn't deal with it for a good reason, in my respectful submission.
The question is a hypothetical one.
It's an if I can try and be precise as I can, my lord, it's an objective question. It's I accept
it's hypothetical as well.
Hypothetical, I said.
That's the way that it's explained in the Blue Sky.
I find this a slightly slippery, if I may say so, I find this a slightly slippery concept. I think I would agree that it's hypothetical in a sense that you're dealing with something that never had happened.
Yeah.
But, I mean, the way that I would submit it should be characterised is it's said to be an objective exercise, except hypothetical exercise. The parameters of that exercise are it's at the date of the decision and it's the information available to the hypothetical decision maker at the date of the decision.
To the hypothetical decision maker, not to the actual decision maker.
Yes.
Right.
I say that's good enough for my purposes because, as I've sought to submit, that the material just was not there on any view. Lords, could I come then to this issue of law? I'm sorry, Lords, I'm in great difficulty in time. Is there any prospect I could have 5 or 10 extra minutes?
Yes.
Thank you very much. My Lords, there is, as you, I think, will have apprehended, an important question here as to what the correct principle and standard of review in respect of Section 3.2 of the Act is. I gave you my submissions in considerable detail as to why I say it's an error of law to hold that Section 3.2 is in any way transposing or incorporating or giving effect to the EU state aid law, market economy, investor principle. My learned friend, in very broad terms, at the outset of his submissions, invited you to accept that conclusion as correct. But in my respectful submission, he hasn't offered you any substantial legal analysis to support that conclusion. The furthest that he's gone in his submissions is to assert that it would be surprising or very surprising, he said, if the Subsidy Control Act was affecting a change, as he put it, from old EU state aid law. So I say that's a fundamentally bad proposition.
It was one which appealed to Mrs. Justice Bacon in New Lottery.
Well, if I could deal with... Can I come on to that, my lord?
Of course.
It was... No, sorry, let me just deal with it very quickly. Lottery, it was common ground before Mrs. Justice Bacon that that was the correct position. There was no argument about it whatsoever. There is no reasoning, no detailed reasoning in my respectful submission in that judgment to support it. And in my respectful submission, I'll try and deal with this as briefly as I can. The proposition is obviously not a good one as a matter of law. I've shown you the TCA, I showed you Article 4 of the TCA. The whole premise of what's been negotiated and agreed between the UK and the EU in the TCA and documented is that EU state aid law is categorically not what we're doing now. I see my lord.
That's a point about interpretation of the Act, of the TCA,
yes,
and whether you use the Vienna Convention.
So
this isn't really an interpretation point, is it?
It is, in my respectful submission, absolutely an interpretation point. I'll seek to explain that if I may. In determining, sorry, let me please, if I may, take my points in turn. The TCA provides in terms, Article 4, that in construing the TCA, EU law is not to be the basis. That's heavily negotiated, intensely political controversial, and a very important part of that treaty. You then have a set of provisions in the TCA which are not derived from EU state aid law. They're principally derived from WTO treaties. There are similarities, but there are differences. You then have the Subsidy Control Act, which is a new Act of Parliament made against that backdrop, again, with its own specific structure and provisions. And we haven't burdened you with lots of the legislative background, but there's no suggestion that it's intended to adopt anything of EU state aid law. And when you read the materials, it is clear it is a new, different, bespoke regime. Against that backdrop, the proposition that there can be any assumption or presumption that EU state aid law applies unless there's positive indication of change, I say is misplaced. I would respectfully, if I may, I would respectfully refer to Lord Justice Zacaroli's judgment in the Bulb case, or your note again, tab 17, page 510, and its paragraphs in particular, paragraphs 73, 76, 89, 96, and 97. I showed you my learned friend's skeleton in opening. This was absolutely common ground throughout the trial. What happened is that the authorities' position changed after the trial, because following the evidence and the submissions, to put it bluntly, this was the only way around the evidential difficulties. You had to apply a principle that meant that you weren't stuck with what the authority had considered. So, my lords, Lord Justice Miles put to me, it's not a question of interpretation. In my respectful submission, it's absolutely a question of statutory interpretation. I showed you section 70 of the Act. It is section 70, it's the express and specific provision telling us what legal principles the court is to apply in dealing with these challenges. It refers to domestic judicial review principles. The EU state aid meek principle is not part of those domestic principles. There are two candidates, my lord, two candidate principles as a matter of domestic judicial review law. One is rationality, and for all the reasons that I've explained in my submissions, I respectfully submit that is plainly the correct and applicable principle. Again, I respectfully rely on the analysis in the Bulb case, which I say supports all of that. I also submit that the alternative candidate, and I think my Lord Justice Miles mentioned this at one point in the argument, that it's never been contended for by the authority, would be domestic law precedent fact. That would be the other domestic law judicial review candidate principle. Now, the reason that the authorities never contended for that is that's a principle which means the court determines the issue for itself on the balance of probabilities. No margin, there's no deference. That's not the correct candidate, in my respectful submission, plainly, because when one reads the words of section 3.2 as I submitted at some length, what we're dealing with here is an evaluative judgment. It's a form of evaluative judgment which admits of more than one possible rational answer. Case law makes very clear you only apply precedent fact when you're dealing with hard-edged factual issues which only have one possible correct answer. Classic example of that, my lords may have encountered it. Who is a child? So, my lords, we say that it follows from that the correct analysis as a matter of statutory interpretation is very clear. We say that the correct analysis is that in applying the section 3.2 test, the applicable principle is domestic public law rationality. Follows from that the court is looking at the position regarding the evidence that was before the decision maker at the date of the decision, and we say it follows from that the tribunal's approach was in error and should not be supported.
You took us to the monopolies case in opening, and the Lord Mustill there said this question of whether it's a substantial part of the UK or whatever
yes.
the test was is a fairly elastic concept.
Yes.
He went some way to accepting that it was an objective question, but then said ultimately it's a question of whether it's rational or not, but in terms of the outcome, it seems, i.e. if someone's asking this question, is it within the range of rational conclusions that this is a substantial part of the UK?
Yes.
Now, supposing here that even on your argument, that the tribunal can come to the conclusion that it's within the range of rational answers that this was on commercial terms.
Yeah.
Even if the public authority hasn't addressed its mind to it. On Lord Mustall's case, the test, that would seem to be okay.
So I would respectfully say not, my lord. So if I just give you my submission about Lord Mustall and those passages, it's page 137, 138 of the judgment. What he says, and this is exactly the analysis I say that my lords ought to apply to section 3.2, is that there is a two-stage process. First stage is the court construes section 3.2. That's an objective exercise, and that's really, my lord, the submissions I've been making about the inapplicability of the Meek principle. That's the exercise in construction. The court then reviews, applying rationality to the decision of the authority. The important point in my submission for the purposes of this case is when the court is conducting that review, the applicable principle is it is reviewing the decision that was actually made at the date of the decision on the evidence before the decision maker. That is the core principle of domestic law judicial review, subject to something being a precedent fact case.
But he says in that case that he doesn't take such an extreme view. He says that this is a jurisdictional question, because the whole question whether the Monopolies and Mergers Commission had jurisdiction at all over this depended on whether it was part of a substantial part. So he said, I accept up to a large extent the argument that this is a jurisdictional question.
Yes.
And then he says, is the answer within the rational range?
So that's why I rely so much on this case, my lord. This is a case where the court is looking at something which is a true jurisdictional question. So it's the gateway to getting into the MC process. Nonetheless, because the decision is concerned with something which admits of more than one rational answer, one's applying rationality. One isn't just making your mind up for yourself, even when you're dealing with a true classic paradigm jurisdictional question. I say that supports the interpretation and analysis that I'm putting to you. Well, can I just check my notes and ensure that I've made... Oh yes, there is one more point to do with my learned friend's submission to you during the course of his oral submissions, that you should hold that it simply wasn't open to us to run our public law arguments. Again, that's not an argument that was run before the tribunal below. It's no part of a respondent's notice. I say it's not open to him. I say it's also not correct for the reasons I explained in opening. Looking at the relevant provisions of the Act, the jurisdiction that's conferred is a general judicial review jurisdiction. And I say that makes perfect good sense when one thinks about, for example, the existence of the statutory guidance. I say it would be most surprising as a matter of statutory interpretation if Parliament had passed an Act, including two provisions, section 3.2 in our case, section 79 in the other, dealing with inextricably intertwined matters, created a judicial review jurisdiction, but did that on the basis that you could take your complaint under section 3.2 to the tribunal, but couldn't take your complaint under section 79, and that had to be the subject of a separate judicial review set of proceedings in the administrative court. Now, my learned friend said to you that, well, there are lots of examples where you have to bring separate judicial reviews. He said that in very loose terms, and he referred to one example, procurement claims. That's not a good example, my lord. Procurement claims are Part 7 actions in statutory tort, so you have a Part 7 claim. And he's quite right, sometimes one does bring a judicial review because you're bringing judicial review grounds that can't be brought in a Part 7 action. His case here is that you need two sets of judicial reviews. I'm not aware, speaking for myself, of any statutory scheme where Parliament has said you've got a right for judicial review in respect of some parts of this Act. You've also got a right to bring judicial review in respect of other provisions, but those go to a different tribunal. I'm not aware of any precedent for such an approach, and I say that's not how you should construe these provisions. Although, can I just check if...
Can I just ask a very brief question? On a section 79 JR claim that the guidance wasn't followed,
yeah,
assuming a thought-out response to that,
yes,
if this is in fact not a subsidy,
yeah,
wouldn't there be an obvious and complete answer that makes no material difference?
It's the same point. I'm going to repeat myself. Terribly sorry, my lord. It's no difference, exactly, my lord. It's no difference, but that's how it would need to be expressed.
Indeed, but looking at it, standing back, if that were done, that would be the obvious answer.
So I would indeed, and I would entirely accept that many cases, that obviously would be a determinative answer, but I would say it's in principle possible that it wouldn't always. It would depend on the facts, in my respectful submission. Could I just take instructions, my lord, and make sure there's nothing else? No, my lords, unless there can be further assistance, thank you very much for the additional time. Those are my submissions.
Well, thank you both very much, and those sitting behind you who've contributed to the very interesting submissions that we've heard. It won't come as any surprise to you to learn that we will be reserving our judgments. You will receive drafts of the judgments in the usual way, which come with an embargo, and as you know, in terms of the embargo are to be complied with. It's the opportunity for you to correct our typographical and grammatical errors and not to re-argue the case. We also hope that you will take the opportunity to try and agree a draft order giving effect to our judgments, or failing agreement, brief written submissions explaining your rival positions, which we will then hope to resolve on paper, and the final judgment will be circulated without the need for attendance in what is by now the familiar way. Thank you all very much.
Court rises able.